Question 311. This type of mortgage loan can be increased without revising its terms. A. Wraparound mortgage. B. Open-end mortgage. C. Closed-ended mortgage. D. Fixed-rate mortgage. Correct answer is B. Open-end mortgage. A wraparound mortgage combines a new loan with the seller's existing loan, but the borrower makes a single monthly payment that covers both loans. The total loan amount typically doesn't increase without refinancing. A closed-end mortgage has a fixed loan amount for the entire term. You cannot borrow additional funds without refinancing. A fixed-rate mortgage offers a constant interest rate throughout the loan term. While the interest rate remains stable, the loan amount itself cannot be increased without refinancing. An open-end mortgage allows the borrower to access additional funds throughout the loan term, up to a pre-established credit limit, without having to refinance the entire loan. This means the original terms, interest rate, maturity date, remain unchanged, but the loan amount increases. Question 312. Tenant Charles notifies owner Sam that Charles surrenders his lease to a unit in a commercial building. Sam has the legal right to do which of the following? A. Signal his acceptance of the surrender by changing the locks on the door. B. Enforce the lease and continue to pursue rent payments from the lessor. C. Both A and B. D. Neither A nor B. Correct answer is C. Both A and B. When a tenant offers to surrender the lease, they are essentially proposing to end the lease agreement early. However, the lease remains in effect until the landlord accepts this surrender. Upon receiving a tenant's surrender, the landlord has a few options. A. Accept the surrender. The landlord can agree to terminate the lease. Actions like changing the locks, after clearly communicating acceptance or in a context where acceptance is reasonably implied, can signal this acceptance. Once accepted, the tenant is generally no longer obligated to pay future rent. B. Reject the surrender. The landlord can refuse to accept the surrender and hold the tenant responsible for the remaining rent under the lease terms. In this case, the landlord would typically need to make reasonable efforts to mitigate damages by trying to re-rent the property. Simply continuing to pursue the original tenant for rent without trying to re-rent might not be fully legally sound and could be challenged in court. Question 313. The following would probably result in the greatest increase in home buying. A. Higher interest rates. B. Lower interest rates. C. Greater supply of housing. D. Decreased supply of housing. A decreased supply of housing typically leads to higher prices due to increased competition among buyers. This would likely decrease affordability and potentially reduce the number of people able to buy homes. While a greater supply of housing can help meet existing demand and potentially stabilize or lower prices, it doesn't necessarily create a significant increase in the number of people looking to buy. It primarily addresses the needs of those already in the market. Higher interest rates increase the cost of borrowing, making mortgages more expensive and reducing affordability. This generally leads to a decrease in home buying. Lower interest rates make borrowing money for a mortgage less expensive. This reduces the monthly payments for potential homebuyers, making homeownership more affordable for a larger pool of people. As a result, demand for housing typically increases, leading to a greater increase in home buying activity. Question 314. Grown siblings can take title to property as A. Tenants in common. B. Community property. C. Joint tenants. D. Both A and C. Correct answer is D. Both A and C. Tenants in common. TIC. Grown siblings can own property as tenants in common. In a TIC ownership, each sibling owns a specific, undivided share of the property. They can inherit, sell, or gift their share independently. Joint tenants, JT. This is another possibility for grown siblings. In a joint tenancy, siblings would typically own the property with equal rights of ownership, unless otherwise specified. There's also the concept of right of survivorship, which means that if one sibling passes away, their ownership interest automatically transfers to the remaining siblings. Community property, CP, is a legal ownership concept specific to marital estates. It applies to property acquired during the marriage. Question 315. If a veteran purchases a home under the Calvet program, the grant deed is executed under the name of the A. California Department of Veterans Affairs, B. the lender for the loan, C. the title company, D. the veteran. Correct answer is A. California Department of Veterans Affairs. Under the Calvet program, the California Department of Veterans Affairs purchases the property. The veteran then enters into a purchase contract with Calvet, often referred to as a land contract or contract of sale. Calvet holds the legal title to the property until the veteran has fulfilled the terms of the contract and repaid the loan. At that point, Calvet will issue a grant deed to the veteran, transferring full legal ownership. Therefore, initially, the grant deed is executed under the name of the California Department of Veterans Affairs. The veteran holds equitable title, which is the right to use and possess the property and to obtain full legal title once the loan is paid off. Question 316. A prospective borrower applies for a loan to buy a property in a poor neighborhood. Although the loan applicant has excellent credit scores and a steady income, and the property has excellent potential for renovation, the local lender turns down the loan app. The lender is probably A. justified, because the property is in a disadvantaged neighborhood, B. in violation of the Rumford Act, C. in violation of the Holden Act, D. likely to have its license revoked by the controller of the currency. Correct answer is C. in violation of the Holden Act. Under California's Holden Act, the lender must make lending decisions based on the worthiness of the borrower and the security property, not on the property being in a certain neighborhood. It is against public policy to refuse mortgage loans or to impose stricter loan terms due to neighborhood characteristics. Another state law, the Rumford Act, prohibits discrimination based on the applicant's race, color, religion, gender, sexual orientation, and other protected groups. Question 317. Which of the following kinds of deed carries no warranties of title? A. Quitclaim deed, B. Trust deed, C. Sheriff's deed, D. Both A and C. Correct answer is D. Both A and C. Certain types of deeds used in real estate conveyances offer the grantee no assurance or guarantee regarding the quality or validity of the property's title. Among these, the quitclaim deed stands out as providing the least protection to the buyer. When a grantor issues a quitclaim deed, they are essentially transferring any interest they might possess in the property, without making any representations or promises that they actually own the property free and clear of encumbrances. The grantee accepts the property, as is, bearing the full risk of any existing title defects or claims against the property. The grantor simply relinquishes any potential claim they might have, without warranting the strength or existence of that claim. Similarly, a sheriff's deed, which is issued to the winning bidder at a foreclosure sale, typically carries no warranties of title. In a foreclosure, the sheriff acts under the authority of a court order to sell the property to satisfy a debt. The sheriff's role is primarily administrative, and they generally lack the direct ownership history and personal knowledge necessary to provide assurances about the title's condition. Consequently, buyers at foreclosure sales who receive a sheriff's deed assume the responsibility for any title issues that may arise. They are purchasing the property subject to any pre-existing liens or encumbrances, without any guarantee from the sheriff or the foreclosed-upon owner. Therefore, both quitclaim deeds and sheriff's deeds are notable for their absence of title warranties. Buyers receiving quitclaim or sheriff's deeds assume greater title risk due to the lack of warranties and should therefore conduct thorough due diligence. It's including a title search and obtaining title insurance to safeguard their investment. This proactive approach helps mitigate potential financial losses from undiscovered title issues. Question 318. On a construction loan, the lender's last payment usually will not be made until A. The building is completed, B. After the expiration of the lien period, C. The close of escrow, D. It is listed by a broker. Correct answer is B. After the expiration of the lien period. Construction loans are disbursed in stages as work progresses. For general contractors, mechanics liens must be filed within 60 days of the filing of a notice of completion and within 90 days if no notice is filed. The final payment is typically held back until the lien period has expired. This is to ensure that all contractors and subcontractors have been paid and that no mechanics liens will be filed against the property. Once the lien period expires, the lender is assured that there are no outstanding claims against the property. Question 319. Homestead protection can be terminated in all the following ways, except A. If the homestead is sold, B. If a creditor brings a legal action against the homesteader in bankruptcy court, C. If the homesteader files a declaration of abandonment, D. If the homesteader files a declaration of homestead on another property. Correct answer is B. If a creditor brings a legal action against the homesteader in bankruptcy court. When the homesteaded property is sold, the homestead protection generally terminates with respect to that specific property. However, in California, the protection may extend to the proceeds of the sale for a certain period, allowing the homeowner to reinvest in a new homestead. A homesteader can voluntarily terminate the homestead protection on their property by filing a formal declaration of abandonment with the county recorder. Filing a declaration of homestead on a new property generally implies the abandonment of the homestead on the previous property. A person can typically only have one declared homestead at a time. While bankruptcy proceedings can significantly impact a debtor's assets, the homestead exemption is a protection within bankruptcy. Federal and California bankruptcy laws allow debtors to exempt a certain amount of equity in their primary residence from being used to pay off creditors. Therefore, a creditor bringing an action in bankruptcy court does not, in itself, terminate the homestead protection. Rather, the bankruptcy court will apply the relevant homestead exemptions. Therefore, the correct answer is B. Question 320. A real estate agency would not terminate if A. The principal revokes the agency on his own accord. B. The property that is the subject of the agency is destroyed in a fire. C. The principal is killed. D. The principal fails to accept an offer brought to him by the agent within the allotted time period to decide, terminating the offer. Correct answer is D. The principal fails to accept an offer brought to him by the agent within the allotted time period to decide, terminating the offer. The principal has the right to terminate the agency relationship at any time, as long as they do so in accordance with the terms of the agency agreement, if one exists. If the property is destroyed, the agency is no longer possible as there's nothing left to sell or lease. An agency relationship is generally terminated by the death of the principal, because the agency is based on the personal relationship and capacity of the principal. The termination of an offer does not, in itself, terminate the agency between the principal and agent. The agent's obligation is typically to present offers to the principal. If the principal doesn't take action within the specified timeframe, usually outlined in the offer itself, the offer might expire. However, the agency agreement between the principal and the real estate agent would likely remain in effect unless terminated by one of the parties as mentioned above.